Today, I'm going to talk about Tarasoff and the alcohol and drug counselor, which essentially has to do with the issue of the duty to protect or addressing the issue of harm to others. As a drug and alcohol counselor, we often hear the statement about harm to others, harm to self, harm to children, harm to elder. Essentially, what we are talking about is what are the alcohol and drug counselor's responsibilities legally and ethically when an issue comes up where a client or a patient in a substance use treatment facility is indicating that they have an intention to harm someone else. So this gets at the ethical issue of our duty to protect. Generally, a person has no legal obligation to help others. For example, if you were walking by a lake or a river and you saw a drowning person and you elected not to do anything to save that drowning person, you have no legal obligation, meaning that if you failed to act and the person drowned and you were sued, there was no legal obligation. There's thus no penalty for failing to help another person. A psychotherapist, however, does have ethical and or legal obligations to protect the public and third parties meaning people or individuals outside of their clients or their patients. So failure to protect the public and or third parties may result in legal action primarily due to negligence. So negligence is sometimes measured by the 4Ds, a dereliction of your professional duty that directly caused damages. Dereliction of duty directly damaging. That's the 4Ds. So clinical duty says that one must provide reasonable care to clients or to patients, and failing to do that leaves the clinician vulnerable to negligence. So our ethical position, we have a duty to protect our client and the public from potential harm by warning them of danger. The legal position on this, on the psychotherapist's requirement to warn a third party, meaning a person, when there's an identified threat to that person's safety from a patient or a client who is being seen by the psychotherapist, was primarily established by the Tarasoff decision in the California Supreme Court in 1976. This is the Tatiana Tarasoff story or saga. So in 1969, a 25-year-old grad student named Prosenjit Potter at UC Berkeley became obsessed with a student, 19-year-old Tatiana Tarasoff. So Potter begins psychotherapy. His psychotherapist is Dr. Lawrence Moore, a psychologist. So he tells Dr. Moore that he is going to kill Tatiana. So Dr. Moore contacts the police and he tells them about the threat, and he recommends that Potter be put on a psychiatric hold. So in this case, Moore is following the ethical principle and duty to protect both his client and the public at large. So after Dr. Moore contacts the police investigate and they leave when Potter promises them that he's going to stay away from Tatiana and he's not going to do her any harm. So the problem here was that nobody warned Tatiana or her family. And so then Potter calls Tatiana, says he'd like to meet with her, and then he subsequently kills her or ends her life. So Tatiana's parents sued UC Berkeley, where Dr. Moore was practicing, and Dr. Moore for negligence. So negligence, again, the professional duty. They said that Dr. Moore was remiss in his duty to protect the public, or Tatiana. So the lawsuit was Tarasoff versus Regents of the University of California in 1976. Now, this was a civil lawsuit. There were no California criminal laws that had been broken. So the difference between civil law and criminal law is that if an individual's rights have been violated, they can take another person or an entity to court and sue them for compensation. You've done me wrong, and although there is no relevant law on the statutes related to this particular situation, I'm suing you because you've violated my rights in some way. And if the plaintiff wins their lawsuit and the defendant loses, then typically the plaintiff is compensated. So, this is a case of suing people for money. In the case of criminal law, it means that the individual has broken a law. A published law, California statutes, code of regulations has been broken. And if the defendant is found guilty, instead of paying off somebody, then it's punishable by jail, prison, and or a fine. So Tarasoff was a civil lawsuit. So the defense argued that Dr. Moore followed patient confidentiality regulations. So he was respecting his client's rights to confidentiality, but he alerted the police, and they said that there was no legal duty to warn the third party, Tatiana. So he did his duty. The argument is that he did his duty by letting the police know that there was a potential threat to public safety, that he had no legal duty to warn Tatiana. So the case ended up at the California Supreme Court. And the Supreme Court's decision was pretty shocking at the time. It said that Dr. Moore did have a duty to protect Tatiana because she was the foreseeable victim of his patient's harm. So in addition to contacting the police, which Dr. Moore did, the Supreme Court said that he was negligent or failed in his professional duty by not also contacting Tatiana. So in this case, that case was settled out of court for an undisclosed amount of money. Just kind of a follow-up to that too. Potter actually was also tried for a criminal conviction for murdering Tatiana and ended up serving 4 years of a 5-year prison sentence for manslaughter. On appeal, his conviction was overturned due to some faulty jury instructions about diminished capacity. Essentially, Potter was arguing that he was mentally imbalanced when he committed the crime. The jury misunderstood what that meant, and the conviction was overturned. So a second trial was not held on the promise that Potter return to India. And last we know about Potter is that he was happily married in India after murdering Tatiana Tarasoff. So let's move over to the key legal precedents established by the Tarasoff case. So the court ruling established a new legal precedent. So the client confidentiality laws must yield to public safety, meaning that if the client says something in the confidentiality of psychotherapy, those confidentiality laws must yield to public safety, which includes now a duty to protect the public and to warn them. So not just calling the police, but you have to protect and warn any individual that you know who is in danger due to information that you receive from your client or clients. And if you fail to do so, that is considered negligence. So this is a quote from the Supreme Court. Once a therapist does in fact determine, or under applicable professional standards reasonably should have determined, that a patient poses a serious danger of violence to others, he bears a duty to exercise reasonable care to protect the foreseeable victim of that danger. The phrase too, under applicable professional standards reasonably should have determined. What essentially the court is saying there is that as a clinician, Dr. Moore, through his training as a clinician, should have understood that professional standards were such, the ethical standards of his profession were such that he should have figured out that Tatiana was in danger, and he bears a duty then to protect her from that danger. Again, there was a big change in standing. Additionally, the court said that in cases such as these, there is no confidentiality privilege, meaning that clients have a privilege of confidentiality. So clients in substance use treatment or mental health treatment have the right to have what they say in treatment protected, meaning nobody can hear about those, whatever it is that they share. But in this case, the court said there is no confidentiality privilege if the psychotherapist has reasonable cause to believe that the patient is in such mental or emotional condition as to be dangerous to himself or to the person or property of another, and that disclosure of the communication is necessary to prevent the threatened danger. So in everyday speech, what essentially they're saying is the client has no confidentiality rights if they say something that makes the therapist believe that they are in a mental or emotional state that they're going to hurt themselves or they're going to hurt somebody else, and that you have to tell that other person in order to prevent the threat and danger. In addition, the court said that the public policy favoring protection of the confidential character of patient psychotherapist communications must yield to the extent to which disclosure is essential to avert danger to others. The protective privilege ends where the public peril begins. So here what they're saying also in 1976 is, look, we the Supreme Court recognize that there are laws stating that a patient sharing communications with a psychotherapist needs to remain confidential. But the Supreme Court is saying, in spite of that, when you must say something to protect somebody else, then the patient no longer has the right to those confidentiality privileges. So what that essentially boils down to is saying the court said psychotherapists owe it to third parties. They have the duty to protect them. And it is on the psychotherapist's shoulders to figure out when that needs to happen. So the psychotherapist now, after 1976 in California, is liable, legally liable, if the patient has communicated to the psychotherapist a serious threat of violence against a reasonably identifiable victim. So let's go back to that again. So the psychotherapist is liable essentially means that they're negligent. If they fail to do so, then they are derelict in their duty. So the psychotherapist is negligent if their patient communicated something to them, or if the therapist should have figured it out, meaning that if the patient, Prashinjit Potter had said something that was more indirect, I feel as if I wish Tatiana was no longer here on Earth or something like that, which wasn't necessarily a direct statement of I intend to kill her. What the court essentially is saying is that the therapist, through their professional standards, should be able to figure out when this means that there's a serious threat of physical violence. Now, serious threat of physical violence also requires assessing that the patient or the client has not only intent to cause harm, but the means to actually cause that harm against a reasonably identifiable victim. So essentially what they're saying there is it's your job or the psychotherapist's job to try and figure out who the victim may be. So, right, wait, hold on. I got to figure out who the victim may be. So this is how the court in that case defined reasonably identifiable. They said, quote, it would be unreasonable to require the therapist to interrogate the patient to try and discover the victim's identity or to conduct an independent investigation. But there may also be cases in which a moment's reflection will reveal the victim's identity. So what the court is saying there basically is the psychotherapist should be able to think about it. If they reflect on this, they may be able to figure this out. And the matter is thus, which depends on the circumstance of each case. So basically the Supreme Court is saying that while you should not interrogate your patient to figure out the victim's identity or open up an independent investigation, meaning you don't have to hire a private detective, if you're able to think about this and put the pieces together, you may be able to figure out who this victim is. And if that's the case, then you have the duty to do so. And by saying the matter is thus one which depends on the circumstance of each case, they're essentially kicking it to the courts and saying that the court gets to decide if the psychotherapist should have been able to figure out who this potential victim is. So let's shift over then and talk about the alcohol and drug counselor responsibilities when it comes to duty to protect, particularly in California as it relates to the Tarasoff legal precedences. So the key question here is the alcohol and drug counselor considered a psychotherapist by legal definition, and thus bound by the California laws regarding psychotherapist patient confidentiality privileges and legal duties, which includes the Tarasoff exception. What that means is that in California, there are laws specifically related to, quote, psychotherapist and patient confidentiality privileges. So is an alcohol and drug counselor considered a psychotherapist by this legal definition? This is very murky and not very clear. This is one of these cases where lawyers will be able to have a field day in trying to debate whether or not an alcohol and drug counselor is actually a psychotherapist. Note that in the 1976 Supreme Court decision, the court used all kinds of words in there interchangeably. They referred to therapists, they referred to psychotherapists, they referred to psychotherapy and psychotherapeutic, and they didn't define what any of those things mean. Now, there is actually a law in California, the California Evidence Code, Division 8, Chapter 4, Article 7, that's titled Psychotherapist Patient Privilege, Legal Statute 1010, in which case there is no mention specifically of alcohol and drug counselors. Building on this, though, the legal stance on whether or not a registered or certified alcohol and drug counselor is providing, quote, psychotherapy, the legal definition of what psychotherapy is, or if they're providing counseling, is also not clear. Now, note that a substance use disorder is classified as a mental health disorder, both in the Diagnostic and Statistical Manual of Mental Disorders, or the DSM-5, and the International Statistical Classification of Diseases and Related Health Problems, which is the ICD-10. So in this case, substance use disorders are considered mental health disorders, and mental health disorders are addressed through psychotherapy. Again, there's no legal statement about whether or not an alcohol and drug counselor is providing, quote, psychotherapy, or if a drug and alcohol counselor is providing counseling. Now, we do know that alcohol and drug counselors are definitely vulnerable to civil lawsuits for professional negligence. Alcohol and drug counselors are clinicians, for sure. They work in the behavioral sciences. They are considered under the broader umbrella of mental health counselors. Whether that's a psychotherapist, licensed mental health clinician, drug and alcohol counselor, there's a big umbrella of mental health counselors. And thus, they are considered clinical professionals. Because drug and alcohol counselors are also professionals, they are vulnerable to negligence then. And note that Dr. Moore was vulnerable to professional negligence prior to the Tarasoff court ruling. Meaning prior to the Supreme Court ruling on this, there was no legal clarification about psychologists, psychotherapists, what their duty was. And after Dr. Moore was sued, he lost. And Dr. Moore and the University of Berkeley were then required to pay a bunch of money to the Tarasoff family because of the fact that they were negligent in their professional duties. So this is definitely an area in which alcohol and drug counselors are vulnerable. In practice, many of the same ethical principles that licensed mental health clinicians have, drug and alcohol counselors are bound by. So while there may not be a legal stance on whether alcohol and drug counselors are bound by the Tarasoff legal precedents as quote unquote psychotherapists, they are bound by a number of ethical principles. So the ethical principle of beneficence, which is the obligation to do good, as defined by acting for the benefit of the patient or client, protecting and defending the rights of others, preventing harm, removing conditions that will cause harm, and helping those who need assistance. Alcohol and drug counselors are also bound by the ethical principle of non-maleficence, which is do no harm. Do not cause pain and suffering either directly or indirectly, and do not allow harm to be caused through neglect. As noted previously, drug and alcohol counselors are also bound by the ethical principle of negligence. Negligence is a failure to behave with a level of care that someone of ordinary prudence would have exercised under the same circumstances. What essentially that means is that you didn't do what somebody else would have done in this same set of circumstances if they had the same professional ethics. Negligence often relates to a behavior of taking an action, but negligence can also consist of omissions when there is some duty to act, as in the duty to protect others. So the bottom line for alcohol and drug counselors is that failing to act when you have knowledge that a client or a patient intends to harm another person is both an ethical violation and it potentially leaves you vulnerable to a lawsuit due to negligence and dereliction of duty. And ultimately, somebody may get hurt due to your failure to act, in the same way that Tatiana Tarasoff lost her life when Dr. Moore failed to act to protect her. Now, this quote from Dr. Grasso in the Advanced Application of Law and Ethics for California Drug and Alcohol Counselors, published in 2017, says, quote, California alcohol and drug counselors need to take reasonable and prudent steps when managing this difficult issue. It will most likely diminish the possibility that legal action against them would be successful, meaning that you should be prudent and take reasonable steps in this murky legal area in order to make sure that you are not vulnerable to legal action and ultimately to protect an individual who may be harmed without you taking action. So applying harm to others' duties as a drug and alcohol counselor. As a substance use treatment provider and an alcohol and drug counselor, you have an ethical duty to provide clients and potential clients with informed consent upon intake into a program. Informed consent means that you advise the clients of a number of things related to them consenting to therapy. But one of the aspects of informed consent is advising the client of their confidentiality rights and privileges, including situations when confidentiality may be broken. So when a client enters a substance use treatment program, they are required in the state of California to be told all of the things that they need to know in order to reasonably consent to treatment. And in that informed consent, it includes telling them their rights to confidentiality and when those rights may be broken. By telling clients that if you were to say anything in treatment that might suggest that you are thinking of harming yourself, harming another person, or that a child, elder, or dependent may be potentially being harmed would lead to a break in confidentiality. These are the mandated reporter requirements. The client then has a right to decide whether or not to continue with the treatment, understanding that what they say might lead to the police being called or a victim receiving a warning. Now, you also need to assess homicidal ideation. Often clients express fantasies of violence. I'll kill him, while they're emotionally dysregulated or angry. So counselors should weigh every threatening statement made in treatment to decide whether or not it's a genuine threat. Often clients will say things like that. Conversely, they'll say things like, I just want to die, right? Or if I don't get my way, I'm going to kill myself. And so part of what a clinician's job is to decide, is that person actually saying that they're thinking of killing themselves, or are they just kind of being dramatic? And they need to assess in the instance. Well, it's the same thing with harm to others. If somebody expresses a fantasy of violence, like if they do that, then I'm going to kill them, you need to decide, are they just saying that, right, in a dramatic effect, or are they actually saying they're thinking of hurting someone? So your clinical judgment ultimately is the decision maker, and you need to assess whether or not this is in fact true. Now, if the client says something and you assess, yes, they do appear to intend to hurt another person, then the process of reporting intent to harm, it typically entails contacting the appropriate law enforcement agency. So in San Diego, this could be the City of San Diego Police Department if the substance use treatment program is inside the confines of San Diego City, or potentially the City of El Cajon if the treatment program's in the City of El Cajon, or the Sheriff's Department if the substance use treatment program is in an unincorporated area, and taking reasonable steps to try and identify the intended victim and make contact with that person too. Now, it's considered best practice that in many cases, you should think about warning your client that you will protect the intended victim and inform the client of the potential consequences of his or her actions. Far from actually causing the harm to happen, by letting your client know, if you are thinking this, I'm going to protect the person that you're talking about, that often will stop them or forestall any potentially dangerous situation. So what this may look like is, a client says, like my ex-wife, just got married and I'm going to kill that guy. Okay. So when you say that you're going to kill your ex-wife's new husband, do you mean to actually harm him? Oh, yeah, I'm definitely, the minute I get out of here, I'm going to hurt him. Okay. Then I need to tell you that I'm ethically bound to warn your ex-wife's husband of your intention, and I need to inform the police. Can we discuss a different way of handling this situation? Now, if the client backs down and says, whoa, well, I'm not actually saying that. I'm so pissed off, right? I'm so hurt. I thought we were going to get back together, right? And it moves into a clinical discussion. Well, then in that case, your clinical judgment may be that your client was just blowing off steam, and making a statement and didn't actually mean it. So again, we are responsible for assessing whether or not this is a valid situation. And obviously, we want to err on the side of caution if we think there is a possibility that our client may actually hurt somebody if we don't do something to warn them. Now, if you are uncertain about whether or not a situation should warrant breaking client's confidentiality to report imminent harm to a third party, please consult with everybody. You should be consulting with your supervisor, your program manager, the certifying organizations. So if you are registered or certified with CADAP, you would call CADAP and say, hey, how should I handle this situation? You can contact the California Department of Healthcare Services. Every substance use treatment facility out there should have an attorney that they have a relationship with that they can contact. Again, this is a legally murky situation, and you want to err on the side of caution here, while at the same time doing everything that you can to protect yourself. So in any situation of reporting intent to harm someone else, or even in the case of deciding not to report intent to harm somebody else, you must document very carefully. If in fact you as an alcohol and drug counselor were ever sued or investigated due to either failing to report, or if your client sued you because you did report and the client says that you broke their confidentiality, the first thing that's going to happen is they're going to look at your documentation. So you want to document everything related to this, exactly what the client said, what your assessment was of the situation, why you chose or didn't chose to break confidentiality to inform the potential victim, what exactly you said to the police or to that victim, who the police officer is that you spoke to. All that stuff needs to be written in your documentation. How you document the process of your decision-making affects your personal and legal liability. Now, court precedents has shown that most of the time, meaning it's not a guarantee, but almost all the time, when an alcohol and drug counselor has been acting with best intentions to protect both the client and the public, they're protected from legal liability. Meaning that if your documentation shows that your client did in fact say that he was going to kill his ex-wife's new husband, you talked to the client, you assessed that he actually meant this, you did call the police, you contacted his ex-wife and told her, because you knew what her name was, that your client intended to do harm, and then your client sues you and it gets to court, then in that case, almost all the time, the court is going to rule in your favor and said that clearly you were working within your clinical bounds with best intentions to protect the client and the public. Where you get into trouble is you don't do anything, you don't document anything, and then you're sued. Then you have a much more difficult time showing that you were not negligent or derelict in your duty. Now, many times the question comes up about HIV and unprotected sex. So what if my client is potentially going to cause harm to another person because he or she has HIV and they're having unprotected sex with a partner? Does that apply to Tarasoff? So in the state of California, there are two regulations. So the Health and Safety Code 121015 in Title 17 of the California Code of Regulations, Section 2500, show that the legal requirements apply to physicians only. So a physician meaning that a medical doctor or an MD. So a medical doctor is required to report. An alcohol and drug counselor has no legal duty to inform the partner. However, the laws state that an alcohol and drug counselor may choose to break client confidentiality and are excused from liability. What that means is that if you break your client's confidentiality and your client sues you, you cannot be held liable for reporting that he or she has HIV and was having unprotected sex, so long as you report it to the public health authorities, so not the client's sexual partner. So public health authorities, San Diego public health authorities, if you were in San Diego County, you can break your client's confidentiality and report it to them. And now it's on the public health authority's shoulders to decide what it is that they're going to do next. However, if you are going to disclose this to the public health authorities, you must educate your client or patient, try and get them to consent that you're going to do this, or to speak to his or her partner, and you need to notify them of your intention to inform. All right, so in summary, the issues surrounding breaking client confidentiality privileges and protecting third parties from harm are complex and legally murky for registered and certified alcohol and drug counselors. So the ethical issues and the legal issues are not crystal clear. However, it is most often going to be in the drug and alcohol counselor's best interest to follow the ethical prescriptions of doing good and doing no harm and protecting a third party if in fact it appears that they may be harmed. You need to make sure to inform clients when they come into programs. If they share anything that indicates that they intend to harm someone else, you will break confidentiality. A documentation, an informed consent document that shows that you told the client this and they signed that document and agreed to it, limits your liability. Essentially, you told them you were going to do this and they agreed to that beforehand. So if they were to sue you later, you're protected. And you need to consult, and document. This is a tricky situation. And whenever a situation like this arises, you definitely don't want to make this decision all on your own, particularly when you're first entering the field. This is a case where you want to get supervisors, program managers, directors, attorneys, basically everybody you can on your side to make sure that you're protecting everybody involved, both yourself and your client and the potential individuals or public who may be harmed. All right, so that is the Tarasoff two-step, a very complicated dance with many twists and turns. Hopefully, this has provided you some education about the legal and ethical issues surrounding potential harm to others and your duties as a registered and certified drug and alcohol counselor to address those issues as they arise.